Jurisprudence No. 1-year Perkons 2018 addresses the authority of the Consumer Dispute Settlement Agency (BPSK) regarding disputes over credit agreements involving fiduciary security rights. In practice, there are often disputes arising from financing agreements between consumer finance institutions and debtors, whether based on mortgage or fiduciary agreements that are. These disputes typically occur when creditors attempt to execute the collateral or fiduciary object due to the debtor's failure to meet their installment obligations. Regarding this issue, from 2006 to 2012, there were two legal perspectives within the Supreme Court. The first perspective held that the legal relationship in consumer financing agreement disputes falls under consumer disputes, thus asserting that BPSK has the authority to adjudicate such disputes. The second perspective argued that disputes arising from consumer financing agreements constitute breach of contract one prestasi and, therefore, do not fall within the jurisdiction of BPSK. Ultimately, the Supreme Court, through this jurisprudence, ruled that disputes arising from financing and credit agreements, whether involving mortgages or fiduciary rights, do not fall under the Consumer Protection Act. Therefore, such disputes are not under the jurisdiction of BPSK, as they concern breach of contract, which should be resolved through civil law mechanisms rather than as consumer disputes. This ruling provides legal clarity that BPSK does not have the authority to handle disputes related to credit agreements involving mortgage or fiduciary rights, as these are not considered consumer protection issues.